In June 2022, we all watched in shock as the Supreme Court overturned Roe v. Wade and gutted women's rights to their bodies and reproductive health care.
Many of us in the LGBTQ plus community were even more shocked when the concurring opinion from Justice Thomas was released, where he alluded to the court's need to review and reverse protections for same-sex couples, including marriage equality and the rights and responsibilities that come along with it.
In addition, with more and more Gen Z and younger millennials vocalizing that they will be sitting out the 2024 election because they're disappointed with Biden on social issues, it's possible we could see even more momentum in the country to revoke the right to same-sex couples to marry.
It feels as if we're on a precipice going backwards on this issue when we're seeing countries such as Estonia and Nepal legalizing same-sex marriage or marriage equality in 2023. So what can same-sex couples in the United States do going forward to protect themselves and their assets to stay on the safe side?
You're listening to Queer Money episode 472, and today we're sharing the top 5 documents same-sex couples can and should be using to protect themselves.
Now, on with the show.
The mission of Queer Money is to financially empower the LGBTQ plus community. Join us in thanking Capital One for supporting that mission.
This kind of gives you a sense for how old this podcast is or how long this podcast has been running. Because when we started the podcast, the need for same-sex couples to do all the things that we're going to talk about today were imperative because we didn't have marriage equality. And then marriage equality came along and it almost felt like, okay, well, maybe we don't need to have this discussion so urgently, right? We can be a little bit more, not passive about it, but it's not such an urgent issue for us.
Oh, I think we were all excited that we were starting to enjoy some of the same legal protections that couples have had for as long as those
Millennia.
legal protections have been in place, right?
Yeah.
For many cases, it's been thousands of years.
Right, exactly. And now it seems like, goodness, we're going back to topics that we talked about in 2014, 2015 when the podcast started. So it's disappointing and it's sad. And I think, why is it important for LGBTQ plus people, especially same-sex couples and those who are married currently to have, to talk about their financial plan, to have a plan? Well, the need to have a plan is important because if you don't have a plan, could be helter-skelter. You might not get the rights and protections that you want. Your money might not go where you want it to go after you pass on, even to your partner, if that's what your expectation is, should you die first. So we know, and as we're going to elaborate on a story that we covered years ago that we thought was no longer applicable, we're going to talk about how not having these protections in place can leave your surviving partner in a precarious position, because not all family members are going to support your wishes when you die. In fact, think about it this way. Are all of your family members who might have an influence over your estate, if you don't actually set up some sort of structure or parameters, are they voting for you when they go in the voting booth every time they vote? Probably not likely. They're more likely voting for themselves. That might align with you, but we all have family members who are voting for the people who are helping to take away our rights.
Yeah, the proverbial Uncle Dick sitting at the Thanksgiving table, right?
Poor Richard.
We all have one of those Uncle Dicks. So one of the things that is important to think about here is that we're going to be sharing a very diverse set of documents when it comes to protecting yourself and your financial assets. And really the important thing here is that they all cover various aspects of your financial life, your health, and things that are important to you when you're no longer able to make decisions. So what we're really going to be talking about are legal documents that are there to make sure that your desires are achieved to protect you, your family, and your assets from someone else doing what you don't want them to do. And that may be protecting you from another family member. It may be protecting you in ways that you don't have to pay as much in taxes as you need to. And it also may be a way for you to actually leave a legacy. So there's a variety of reasons why someone might want to use these kinds of documents.
Yeah, and I think it's important to note that this is a conversation that straight married couples should be having as well. It's just less urgent because there's more of a chance that family members will support their wishes, even if they're not documented after they pass on. But there's just a more of a risk for same-sex married couples to not have their wishes carried out by some family members if they get access to your pocketbook. That's why we're revisiting this conversation that we thought we were no longer needed to have.
I think one of the other reasons why I think it's important for same-sex couples is, for many of us, we didn't follow the traditional path of finding somebody in our late teens, early 20s, mid 20s, getting married, having a family, acquiring assets together, and have these decades of experiences that are together. For a lot of queer folks, and especially slightly older same-sex couples, you may have had experiences that many straight people have, like buying a home or acquiring assets through a retirement account. A lot of those kinds of things, you maybe have been doing that all on your own for a long time before you met the right one and decided to be with that person, whether you're married or not. And so this really can help solidify what your purpose is or what your desires are. Whereas I think for a lot of straight couples, it's kind of, well, we know that this is a family unit and we know that these people have been together for 25 years.
So we respect that.
Yeah. And they respect that.
The big thing.
Right.
And if nothing else, if this particular episode becomes moot because marriage equality isn't reversed in some way, shape, or form, then this can help you create legacy, create a legacy for the people who come after you, right? We've talked a lot about generational wealth and what that looks like in the LGBTQ plus community. It looks a little bit different because most of us don't have children, so we have to be a little bit more strategic with how we transfer our wealth, and hopefully a lot of our money is going to LGBTQ plus people and causes after we pass away. And if this particular topic, the way we've designed it, becomes moot, at least it can help create that hopefully generational wealth within the community and build a stronger future for everybody else. So I think maybe now is a good time to sort of set sort of the bar with some historical context as to how we got to where we are. Obviously, before 2004, marriage equality did not exist in the United States, right? That didn't happen until Massachusetts had its landmark decisions to provide marriage equality or same-sex marriage for same-sex couples. That took place in May 17, 2004. And then, of course, that sort of was the slow launch pad. I'm sure for some Republicans, it was a precipitous slope when in 2015, June 2015, that the U.S. Supreme Court struck down all bans on same-sex marriage and legalized it in all 50 states. And I remember, I'm sure we can all of us remember where we were that night. David and I remember we were sitting on our couch, we were watching TV, and we just didn't believe it was going to happen. Like it wasn't even on our radar. Like even a week or a month or two prior, this wasn't a thing that we were like, oh, this is going to happen. This is going to happen. It just felt like it was just another hurdle we were going to have to cross, and it's more than likely going to be a setback. And then all of a sudden, lo and behold, that evening we're like, we can get married now.
Yeah.
The hell does that look like?
Yeah.
And then of course that was the Obergefell and Hodges decision. So the evolving legal landscape for same-sex couples has been evolving for quite some time, and it's been pretty drastic over the last couple of years. Unfortunately, the current climate isn't so great for LGBTQ plus people, admittedly, specifically for trans and non-binary folks, with the organizations such as Alliance Defending Freedom trying to attack our community in every which way, shape, or form, and in fact, making up cases that don't even exist, such as the wedding site planner who nobody ever asked her to plan their wedding.
It's all lies.
It's all a lie, and of course,
bullshit.
Our Speaker of the House, Mike Johnson, helped support that, and so now we know who the people who are in power. I am quite fearful that Trump will will win in 2024, and that he will continue to do what he did before he lost the election to Biden, and that things will actually become a little bit even more precarious for the LGBTQ plus community. So unfortunately, I personally am not in a hopeful place, in part because of what David said in the intro, that a lot of Gen Z and millennial LGBTQ plus people and in general are opting out are talking about opting out of voting because they're just not happy with what Biden has done or what he has not done. Yeah, that's kind of where we are at that point. And now we're at today. So what do we do?
Yeah. So we're going to talk about some specific documents, and we're going to cover these somewhat high level. Our plan is that later on in 2024, we will have dedicated episodes to each of these types of documents with a little bit more detailed information about what needs to be in them and what they do for you. So we're going to cover this at a high level. So starting off, probably one of the most important documents that same-sex couples and individuals themselves would want to think about having is some type of will. Now, there are a couple of different types of wills, but first of all, a will is a legal document that describes how you want your property and other assets to be distributed or handled after you pass away. So the will itself specifically, that is designed for, this is what happens with my things after I pass away. But I mentioned that there are two different types of wills. There is a will that is designed to focus on your assets, and then there's also a living will. And a living will is slightly different. A will is, first of all, a will is designed to guide your loved ones or the courts about how you want your estate distributed after you pass away. A living will makes sure that what is going on in your life medically before you pass away, that people respect your wishes. So it kind of defines the kinds of things like, do I have a do not resuscitate, or how long do I want to be in a situation where I'm on life support? Those kinds of things can all be defined in a living will. So there's two different types of wills, but more often than not, we will focus on the will that defines what happens to your assets after you pass away.
I think it's important to note here that wills aren't just for rich people. I think there's this misnomer that only rich people, and rich are always people who have more money than you, right? Not the amount of money that you have. But wills are for everybody. So even if you think you have nothing, you definitely want to talk to an attorney. They will help you identify that you do actually have assets. There are things that you're going to want to make sure go to the right places, the right people, whatnot, after you pass away, whether that's your multi-million-dollar fortune or where Muffy, the puppy, goes after you pass on. You want to make sure that everything, or Mitzi, the puppy, I don't know, Mitzi, the kitten, goes after you pass on. You just want to make sure you have things taken care of. And this is really important if you are going to have a surviving partner, currently a surviving husband or wife, because you want to make sure that they're protected after you're gone, because you're dead. You're not going to care, but they're going to have to survive after you. And if you don't have very friendly family members, unfortunately, suddenly your surviving spouse becomes a target.
And I think that that's the important thing with a will, is a will, when you create a will, you choose someone that's called an executor. The executor is the person who basically says, I'm going to follow the rules that John or David set up to what to do with their assets when they pass away. And the thing about that is, it is someone who you choose, so you know this person fully understands what your choices in life are, and they agree with them. And it's really important, because we'll talk about what happens if you don't have a will or executor a little bit later on. But really what's important here is that you're choosing the person who agrees with and affirms who you are and what you want done with your assets. And it's your opportunity to explain thoroughly to them what it is you want to have happen when you pass away, or even with your health care, what happens if you are incapacitated.
A great business idea is for someone to create a coalition of drag queens and drag kings who are trained and prepared to act as executors for all surviving gay people who die.
There's a new purpose for the royal courts, right? The drag royal courts.
Yeah. So how people would turn over in their grave, and mom and dad, if they're still surviving, would be just go nuts if they had to go to court and have their gay son's estate protected by a drag queen. I love that stuff.
Tired of all the credit card offers you get from your current credit scoring app? Download CreditWise by Capital One today to avoid them.
Okay, another document that you should get. Very often we're like, you might want to consider this, you might want to consider that. With what we're talking about today, you definitely want to get it. There's no ifs, ands, or buts. The other,
And we're not, this is not a pointing our finger at you, you should do this. This is,
yeah, we're not scolding you.
you should protect yourself. You want to protect yourself, and these are the tools that you can do it with.
Right. This is like the legal condom.
Yes.
The next layer of that legal condom is a power of attorney. And a power of attorney is a legal document that allows someone else to act on your behalf. And of course, as with the will, there are two different kinds of powers of attorney, and one is pretty synonymous to the living will. The two types of powers of attorney are one, the financial, and the other is the healthcare power of attorney, otherwise called an advance directive or living will. But the financial power of attorney is often used for people who can't manage their finances because they become incapacitated in some way, shape, or form. Get hit by a car and you're on life support. Somebody still needs to manage your money while you're still alive. And of course, if you're on life support, who's gonna decide when and is the right time, or what are the right conditions for when that plug is pulled? And that's where the healthcare or power of attorney or the advance directive comes into place. So that's the big distinction between the two.
Yeah. Yeah. The power of attorney is an interesting document because it does allow somebody to make decisions for you when it comes to your finances, and you don't have to be incapacitated, but it really is someone who you've talked with and have an agreement with, that they understand what is your life's mission or purpose is, and they're going to make financial decisions for you. A lot of celebrities actually have power of attorneys because they are involved in a lot of different things, and they don't necessarily want to be making all of the financial decisions or carrying out all of the financial activities. So they hand over some of that responsibility to a power of attorney. All of us can do the exact same thing. As you mentioned, John, what we're talking about here is not for wealthy people. There are a lot of people out there who have power of attorneys. Maybe you have a son or a daughter, or maybe you have a family member that you choose to be a power of attorney to act for you in case you can't, or when you decide you don't want to.
Yeah, exactly. We see lots of situations as parents get older, their children eventually become power of attorney to help them sort of manage their finances, especially if the partner who did most of the managing of the money passes away. Then the children oftentimes will help the surviving parent, and that's what this does. It allows for the power of attorney to call the brokerage firm to place trades on their behalf, or to request checks to pay bills for whatever healthcare or medicine, or even to pay the mortgage, whatnot. So those are the two big powers of attorney that you want to get.
The next set of documents isn't necessarily a true document that you would think of going to a lawyer and having them draft up, but it's more along how you designate assets when you're creating contracts. So what we're going to talk about here are the various ways that same-sex couples or two or more individuals can own property jointly, because more often than not, when we come together as individuals, we do end up bringing our assets and joining together. And so we want to make sure that through our contracts that we're defining how it is that we want our assets to be designated as to who owns them. So we're going to list a couple of different types of ownerships that you can have on your documents. And we're going to kind of use the example here of owning a home together, because that kind of makes sense. A lot of couples do own a home together, and there can be a lot of ways in which that home is acquired. It can be acquired before the couple comes together. It can be acquired while they're together. So the first one is what's called joint tenancy with rights of survivorship. This is basically the kind of default that happens when two people open up an account or two people buy a home together. It's typically listed as kind of the default when people buy something together or open an account together. And basically what it means is that both people own the account, or both people own the asset, 100%. So if one of them passes away, it automatically goes to the other. But so it's kind of the whole idea of joint is really important here. This is something that both people own.
Both people own 100%. It's not a 50-50 split. It's
Right.
such as our house here. David and I each both own 100% of this house that we're sitting in.
Yeah. So if I pass away, John gets 100% and vice versa.
And typically, unless it's stipulated otherwise, in most cases, with accounts, with property, whatnot, unless it's otherwise stipulated, typically joint tenancy with rights of survivorship. There might be some exceptions for some assets in some states, but typically it's that way, and that's why where pre and post nuptials come into play. Why assets that a partner might have acquired before they got married might be considered separate, and assets that have been acquired after a couple gets married are typically, unless otherwise stipulated, considered 100% ownership of both parties.
Yeah.
But you can designate that differently, as we'll talk about shortly here. Otherwise,
Yeah. One of the ways that you can designate that differently is what is called tenants in common, which means that you both own it, but you have fractional ownership. So for example, you may have an 80-20 split. So let's say, for example, when two people come together and they purchase a home, one person is coming with all the down payment, or maybe they have assets that they've brought to the home and they want to have, or the couple has agreed that they're going to designate that the majority ownership is in this person's name. So some examples might be, if a couple comes together and one of them already owns a home, they may designate or deed the property as tenants in common, so that the spouse who has come into the relationship or come into the home, they may get designated as having a portion of it, but the primary spouse who purchased it, that spouse may have a reason to distribute that to or give it to someone else, say, for example, their children, if they choose to.
Exactly. And both joint tenants with rights of survivorship and tenants in common, you don't necessarily have to be married. Anybody can do this. For example, what you'll oftentimes see tenants in common are for when more than two people get into a business together and each owns a different fraction of that particular business. You divide that up on paperwork, and that's pretty much a tenants in common relationship. The next option that you have is called a tenants in entirety, and this is not available in all states. It is in most, but not all states. So you have to check with a local attorney. Sometimes your accountant might be able to help you out with this. But this is when both own 100% but cannot transfer to anyone else without consent of the other. So basically what that does is it shields the assets from, in most cases, really creditors. So that if, for example, I have a lot of debt, and then I also have, my own house that I own. If David and I have tenancy by entirety with that additional house, and I die with my debt still, the banks and creditors can't come over and say, well, I'm going to acquire that house of John's because that's protected under the tenancy by entirety, and creditors can't access that because it's David's.
Yeah. It really is a way of protecting your assets. Tenancy by entirety is a way of protecting your assets. It's something that some couples may choose to have because it's another way of kind of protecting in a prenup situation, right? So one of them couldn't go and sell the house out from under the other, whereas joint tenancy, you technically could, because you truly own 100% of it.
And if you're married and one or both of you has a lot of student loan debt, this way could be a way to protect your assets should one of you die that has a lot of student loan debt, so that the other one doesn't lose their assets to help pay off your student loans.
Yeah. All right, the last one we're going to talk about here is community property. This is where the property is acquired during a marriage or the lifespan of the partnership, and it belongs to both people together. This is very similar to joint tenancy with rights of survivorship, but it really kind of designates that this is This is the property, and this can include debt. This is the property that we own together as a result of or because we were married when we purchased it.
Exactly. And it's also helpful to know that you can choose different levels of property ownership for different assets. So your house could be under, tenants in common. Your investment accounts can be joint tenants with rights of survivorship. You don't have to just choose one, and that's sort of the umbrella property distribution for all your assets. You can pick and choose whatever makes the most sense for you.
Yeah, and I think that this is again an important one for folks who come into a relationship, and one of them may have owned or had a large amount of assets prior to coming into the relationship that they want to designate or have separate because they have another purpose for it. They have an intention for it, and when they come into their relationship together, they don't want everything to be just 100% owned by both of them.
Yeah, I can see that scenario popping up a lot when there's a big disparity in age, and the older partner might have children,
Yeah.
and they want to be able to protect their children while they also want to take care of a surviving partner should they pass away. So the next document we're going to talk about is more specific for unmarried couples. It is a cohabitation agreement. This is the document that you want to have outlined that'll help decide the financial and behavioral rights and obligations between both unmarried partners. Other things you can add into that is David is required to have a smoothie on my nightstand every morning before my eyes open. You can customize it that way. Your attorney might push back on that.
No.
But you're paying him, so make him do the work.
Yeah. Again, this document is really designed for folks who are not married. So if you're in a domestic partnership or you live in a state where common law marriage is used, you may want to make sure that you're looking at this kind of document. For folks who are anti-marriage because they feel like it is conforming to a heteronormative way of living, this would be the important document that you would want to have when it comes to anything that you own together, whether that's accounts or a home, whatever it is. You want to make sure, because this then would stipulate what happens. And the reason why this is so important for unmarried couples is the example that John talked about in the opening. Tom Doyle was a gay man who had lived in New York with his partner for 55 years. They had lived together for 55 years. They had a brownstone. His partner passed away. Now, the brownstone was originally acquired by his partner and was 100% in his partner's name. But because they were not able to get married, because marriage was not legal at the time, his partner's nephews and nieces recognized the value of the home in New York. We're talking about a brownstone in Manhattan. It was valued at $7 million. And this is back in, I think, 2013 or 2014. So we're talking about a really nice home. And his partner's nieces and nephews took him to court to try to kick him out of the house because they didn't believe that the two of them were married. And this was a court case that was widely publicized, not only in New York, but in...
It was originally in the New York Times, then it got picked up all across the world, I think.
Yeah. And so really what we're talking about here is, this is why this is so important. You may be living with people who you think know exactly and will do exactly what you want, but that could be a bunch of bullshit once money gets involved.
Exactly. Once you realize it's $7 million, oh, well, you weren't technically married, and suddenly we don't care for your partner so much, even though we spent the last 15 Christmases with them.
Yeah. Fortunately, this story has a somewhat of a happy ending in that because the court case went on for so long and was dragging out, the nieces and nephews decided to allow Tom to live in the house for the rest of his life.
Right.
He still does not own the home, but they allow him to live there.
And now he can't inherit that to anybody that he would like to inherit it to. It's going to go to his partners, which he may have wanted to do anyway prior to them all becoming jackassholes, but might have changed his mind since.
Right.
It's navigating all these nuances this is why we have a Queer Money podcast, right? Because money is not the same for everybody, right? Gay, same sex couple, or I'm sorry, straight couples don't have these concerns, right? They have similar related concerns, but
You may still have jackhole nieces and nephews
Right.
who want to get to your assets, but more often than not, it's going to be a pretty easy court decision when the court says, oh, yeah, you two were married. There's no reason why this asset should be transferred to these
right,
jackholes.
a straight couple gets married, and everybody's like, "Oh my God, the heavens have shone down. God has said everything is both theirs," and it's gonna be hard to separate it otherwise, right? Well, we don't get that privilege, right? And so this is why we have a podcast called Queer Money. This is why we talk about LGBTQ plus money on a regular basis. But I think it's still hard to navigate. It makes me wonder, like, we need to create like a Queer Money retirement club or something, like where we can talk about this more in depth and get more sort of have people sharing their personal stories so that we can get personalized and customized answers. I don't know. It's just something to think about.
Then, right. The next document we're going to talk about is actually not necessarily a document, but it's an important step that you want to take when you're opening up specifically retirement accounts, but it doesn't necessarily need to be a retirement account, and that's beneficiary designations.
Yeah, you'll typically see these on IRA, Roth IRAs, 401ks, 403bs, etc. They do apply to a lot of other things, but that it's a beneficiary designation. It is important. There are so many situations. Your will or your trust, anything drawn up by an attorney, does not supersede beneficiary designations on your accounts. So we talked a couple of episodes ago about how there are like $7 billion in 401k assets out there that nobody's coming to claim or something like that. I forget. That might be a completely off the mark number. But there are all these 401ks out there that people have forgotten. They've left at previous employers, and nobody knows that they have that until, of course, when somebody dies. And then somebody goes and they do a financial investigation. They realize, oh, okay, well, David had a 401k over this company and a 401k over there. And they were on, and the beneficiary listed on those accounts was his ex-wife. And so as a surviving,
David doesn't have an ex-wife.
as a surviving partner, even if the will or trust says that I get all of David's assets, not those two 401k accounts, because he has his ex-wife listed on there as the beneficiary. Your beneficiaries are super, super critical to make sure that they align with your wills and estates.
Yeah. This is, it's an important because it's your first line of defense of saying, this is what I want done with these assets. And when you really think about, I mentioned earlier that we would talk about what happens if you don't have an executor, or you don't have a will or an estate. I'm sorry, if you don't have a will, what happens is assets, when you don't name a beneficiary or you don't have someone designated as who gets the assets when you pass away, what happens is those assets then are pooled into what is called your estate. And the estate process depends on each state and county. So especially if you live in a red state, you want to be very careful. But it is almost whoever gets there first ends up being the executor, who it's almost a race to the county court to determine who it is that is going to be the executor of your estate. Now, most of the time when you're married and you're in a heterosexual relationship and you're married, it automatically defaults to your spouse. In same-sex marriages, you may find that an executor may be named who is not your spouse, and it could be a family member, or it could be a ward of the state, someone who specifically works for the state or the county who's going to decide what happens to your money.
That could be like Ron DeSantis now gets to decide who gets your assets after you die.
And do you want that bullshit happening?
No,
Absolutely
sir.
not.
Right.
So that's why it's so important, one, to have the will, but two, to have these beneficiary designations. The other thing about these designations, if you are picking a spouse, the great thing is, for most of your account types and most of the assets, when you designate a beneficiary and the assets are transferred to your spouse, that is not a taxable event. So I have a 401k or I have a IRA rollover account. I pass away, it automatically goes to John because I've named him as a beneficiary. It transfers to him. he doesn't pay any taxes, and he starts using those assets just like he would his own.
Get that Lamborghini I've always had my eye on.
You're right. His his own. He treats it as his own retirement account.
Now, of course, that's a benefit that we would lose if Justice Thomas gets his way and they nullify same-sex marriage.
Yeah, and to be honest, that was the first court case, and that was the first. I'm gonna forget her name.
Windsor, Edie Windsor?
Yes, Edie Windsor. So that was what her court case was really about, was here's this woman who has been married. I do that in air quotes for those of you who are listening, but she's been married for decades to this woman, and this woman, her wife passes away, and the assets get transferred over to her as a non-spouse. She has to pay taxes, and in the case of Edie Windsor, she was paying hundreds of thousands of dollars in taxes that, had that person who she had been married to been a man, would have not happened. There's a part of the pink tax, right? So this is why it is so important. When assets are transferred and you're not married, you, of course, you still can designate someone, but they will pay taxes on that when they start to withdraw those assets.
So here's a life hack. Every year when you file your taxes, for those of you who pay your taxes, and when you switch out your batteries in your fire alarm, also confirm the beneficiaries on all your accounts, even if you swear you did it last year.
Yeah.
Just double check. It takes a couple minutes. In most cases, you can just log into your account and easily find who's listed there as a beneficiary. If you have a 401k or 403b and you can't easily find that, talk to your human resource department.
Yeah. And I have a personal story behind this. The first person I ever dated, Victor, when I met him and started to find out a little bit more about his family, he told me a story about his dad. His mother was Vietnamese, born in Vietnam. His dad met her while he was over there. And the two of them got married and ended up having 4 children together. He had been married previously, and he had a life insurance policy where he designated his wife as his first wife as the beneficiary. He never changed it to his second wife, who he had 4 kids with. When he passed away, his $600,000 life insurance policy, 100% went to a woman he had been married to 30 years ago. His wife, with 4 children, got nothing. That was the only life insurance policy that he had. So here his wife and her 4 kids, one of them was my boyfriend, she ended up living on food stamps and Social Security, and all those kids were getting Social Security. They lived at the poverty level, basically at the poverty level, because he didn't designate his second wife as the beneficiary. You don't want something like that happening to your family.
Absolutely not. Okay, now that we're sad, let's move on to the next document that you want to have, and that is a trust. So what is a trust? A trust is, in general, and there are ways to sort of to morph it, but in general, a trust is a relationship in which one person holds title to property subject to an obligation to keep or use the property for the benefit of another. So we all heard about trust fund babies. That's what this is.
Yeah.
And that's sort of, in layman's term, that's what this is. And you can pretty much do anything with a trust that you want to. And there's all sorts of ways that you can customize it, right? So somebody can't inherit the money until after they reach 35 years old, or they have to graduate college, whatever. There's all sorts of variables that you can add to that. But in general, it's titled to a property subject to the obligation to keep or use that property for the benefit of another.
Yeah. And this oftentimes is used, trusts are oftentimes used in specific cases of where you want money to be, how you want it to be used when you may want to protect or support someone else. So for example, if you have a spouse or a child who have special needs, or are at the point in their life where they need special care, this is a great way to designate how it is that your assets are used to make sure that they are taken care of for the rest of their lives, if that's what you're able to do. The other thing is that a lot of people will use trusts to designate money for specific charities. That way the money is doled out exactly the way that they want.
Exactly. Trust can, but not always, be used in a way to protect assets from estate taxes. We talked about those tax loopholes and how rich people don't pay their fair share. This is one of the ways that they protect their assets from taxes, from going to the government. So they make sure that all of it goes to their children. Granted, we're not talking about necessarily the super rich here, but let's do exactly as the super rich do, help create that generational wealth that we talked about earlier. But all that, of course, you want to definitely confirm with an accountant. You want to make sure you customize the trust appropriately, or an attorney, customize the trust appropriately, and you want to make sure that you understand the laws, rules, and regulations in your state and county, because there are some variables based on where you live that can affect exactly how everything that we've talked about can be affected.
All right. So those were the top 5 documents that we want to encourage you to use to protect you and your spouse or your partner. So let's go through them again. 1, a will or a living will. We probably should say "and" on both of
do both.
on that. Yeah. A power of attorney and a medical power of attorney. A property, the property ownership type on your contracts when you're creating contracts for ownership, or you're transferring ownership because you're now married. Make sure you're using the property ownership type that's applicable to you and your partner. Trusts, and then beneficiary designations.
And what you want to do is you can store all of this information electronically. You want to make sure it's easily accessible for yourself, no matter where you are in the world, in case you need to access it for some reason. And you also want to make sure that your executor or a designated person in your family knows where all this information is when you pass away, so they don't have to play hide and seek to find out where everything is.
Or they're not going to try to use it as leverage against you or somebody else in the family.
Exactly. And keep all that cataloged. So thank you for paying attention to another episode of the Queer Money Podcast. Stay tuned for your Queer Money Takeaway. Start your journey to financial independence with a checking and savings account that doesn't nickel and dime you with fees. Get a Capital One 360 checking or 360 performance savings account at Capital One today. Thank you for not only paying attention to another episode of the Queer Money Podcast. Thank you for listening, watching, and joining us for another episode. Get this week's Queer Money Takeaway in this week's newsletter by subscribing in your podcast player or the YouTube link below.
Join us then this Thursday when we cover the most affordable LGBTQ plus friendly city to live in our home state, or
your home state,
my home
second
state,
home state,
Colorado. And next Tuesday, when we answer a question about what to do with a 401k if you're not a U.S. citizen and you're no longer living in the United States.
Thank you, and have an amazing week.